Good afternoon. My name is Don Nguyen. I'm a Florida bar licensed attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with a case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you're sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I will swear in all witnesses. If you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, thank you all. You may be seated. Okay. I'm going to go ahead and approve the draft of the minutes from September 8th, 2025 meeting that was sent to me. So let's go ahead and get that squared up and out of the way. And we'll move to agenda item 4. There are no municipal appeals on the agenda, so we'll move into the lien reduction hearings. So the first and only one is for 925 Cleveland Street. This is for Robert Kirk and Crystal Kirk Cook.
I have multiple exhibits, including the lien reduction application. We've got the Brevard County Property Appraiser's property report, the list of the total fines and associated invoices, copies of those liens, and then the previous orders imposing the fines and liens for you.
Thank you. Thank you. You can go ahead and begin.
Okay. So this is the lien reduction request from Robert C. Cook and Crystal Kirk Cook. The address is 925 Cleveland Street. The respondent on the lot cleaning case was Paul Goglecki, and his mailing address was 4049 Blue River Drive in St. Clair, Michigan, 48079. Our violation address is 925 Cleveland, and that is the same for the mailing address. And there were 3 violations: overgrowth, trash, junk, and debris, and windows, skylights, and doors. So on June 29, 2011, an inspection of the property was completed on case number 11806 by Code Officer Bob Crisco, at which time a notice of violation was issued for violation of 13-26 for overgrowth. Certified mail was sent to the respondent. The re-inspection was completed July 21st, 2011. No change was found in the condition of the property, and a request for the lot cleaning was sent to the city contractor. The follow-up inspection on August 3rd, 2011 confirmed the property was cut and the violation was closed. The invoice for the lot cleaning was sent to the respondent on August 5th, 2011, and the City of Titusville filed the lot cleaning lien on February 20th, 2012. So on October 31st of 2011, a quitclaim deed was recorded listing respondents Robert C. Kirk and Crystal Kirk Cook as the new owners. So the original hearing for Special Magistrate Case 25-33 was completed on March 10th of this year. The respondent, Robert Cook, was present and provided testimony. We had 2 compliance dates, one for the trash, junk, and debris, the second for the windows and doors, and the admin cost in the amount of $216.58 was imposed. So on June 9, 2025, the Massey hearing was completed for the trash, junk, and debris compliance state. They were found in violation and liens were imposed starting June 7th, 2025. And again, the administrative costs were confirmed. On July 14th of 2025, the second Massey hearing was completed for the violation of the windows. Again, it was found that they were in violation and fines were assessed starting July 12th, 2025. So on July 18th, 2025, I completed a re-inspection of the property and found that section 12-23 of the trash, junk, and debris had been resolved and the fines were stopped on that day. On September 8th, 2025, the property passed final inspection on their window permit and the property was found in compliance and fines were stopped on that same day. On September 17th, 2025, the Code Enforcement Department received the application for the lien reduction from Robert Cook. This application is presented in accordance with Titusville Code Ordinance Section 3171 for the special magistrate's consideration. The total daily fine accrued was $9,900 with lot cleaning and admin costs totaling $336.08 for a total of $10,236.08. The applicant is requesting a reduction in the amount of $9,400. So once again, conclusion of facts for this case, February 20th, 2012, the city filed the lot cleaning lien for code case 11-806. On June 9th, 2025, the special magistrate found the respondent failed to correct violations of 12-23 for trash, junk, and debris. $100 a day fine started on June 7th, 2025. On June 14th, 2025, the property is found in violation of section 30414 for the windows, and the $100 a day fine commenced on July 11th, 2025. July 18th, 2025, the property was found in compliance for trash, junk, and debris. September 8th, 2025, the window permit was completed and the property found in compliance. And again, the applicant is requesting a reduction in the amount of $9,400. So these are from the old 2011 case. The picture on the left is prior to the lot cleaning, and the picture on the right is after the city contractor cut. These are photos from case 2533, the initial hearing showing windows, trash, junk, and debris. So this is from the first Massey hearing where the trash, junk, and debris fine was started. This is from the second Massey hearing, showing the windows had yet to be corrected. This is from Massey hearing 2. And these are our compliance photos for the trash, junk, and debris. And these are compliance photos for our section 30-14. And that's all I got.
Thank you. Mr. Kirk, are you able to come up here, or you just want to speak loudly where you are?
I'll sit in the chair.
All right, that's fine.
It is what it is. I've had some sickness in 2023. The storm come through and messed up some of the windows, but while I was in the hospital, I get a phone call from my daughter and my sister, and there's 5 people in my house. I don't even know who they are. Okay, I was in ICU, and they didn't want to bother me because the doctor got upset. I was at Wichita Hospital. I was in and out 7 times, but you know, the problem that I had this year was my aunt had sclerosis, which she passed away. She got murdered March 4th, and she was going to help me. She's actually worked with me and stuff, and they know that, you know, with a situation with my health and stuff. But then I go to get the windows from Coastal Glass, and he said, look, we're 6 to 8 weeks out. They were lucky. I said, really? So he said, look, you're better off to go to Home Depot. He says, you're a vet, you'll get 10%, plus if you fill out one of the new credit cards, and then you get another 10%. So I did, and I read up, and they had the best windows. They had bought out Anderson Windows, one of their factories back in 2018. So I got the top of the line, and I'm glad we did because it's making the house a lot bigger. And then we, as far as the trash goes, okay, there's no sense in that, okay? We have 2 people in the house that are no longer there, they're gone, and we've got all that under control. Grass is being mowed, everything's like it is, but the house is for sale. I got grandkids and family waiting on me in Alabama, and I want to get out of here and get up there with them. But that's pretty much, you know, where we're at on it. You know, I was kind of wishing that the original time that, I mean, May's been great. I mean, she's been like an angel to me. She brought the law enforcement officer to my house to do a blanket trespass, where all I have to do is pick up the phone and boom, they're in silver bracelets on their way to Wayne Ivy Arm Bar Hotel. And so, yeah, but, and I don't know, that the neighborhood there is so-so, but I go to bed early, you know, because of the health issues and stuff, and can wake up, you know, go to the bathroom or something and hear noises on the porch, and my cameras on the porch have been stolen. You cannot get a Amazon UPS package or nothing delivered because it'll be gone. And it's just, and I've gone out there, and there'll be 8, 9, 10 people on my porch. Well, she hooked me up with the officer of Titusville Police Department. Now all I have to do is pick up the phone, they come out, and they're out of there. And she was there one day when we were getting the paper signed for the lien reduction, and some guy, I don't even know, I asked her if she knew him, just goes in my yard and going around to the back of my house. I mean, it is just bizarre, insane. And, and I think what a lot of it is, the word got out that I was sick, wasn't doing well. A lot of people thought I was not going to make it when I was in the hospital, and they accepted it as weakness, you know. And my daughter and my sister don't live in a neighborhood like that. They don't, you know. And my aunt that got murdered, she definitely don't. And but you know, it is what it is. I'm just asking for mercy. I don't want to pay no more than I have to, but I realize, you know, we're guilty. We got to pay something, and you know, leave it.
Right. Officer May, I think the photos were from September. Have you been out there recently this month? Have you seen what it looks like now? Or?
Yes, I went by this morning.
Okay.
The trash and debris is remaining picked up. We haven't had a return of that violation,
Okay.
so.
I'm very happy to see the status of the property now. Looks considerably better. I do remember last time you were here, you know, I do remember the issues with the squatters or the tenants or whatever they were, and I do understand that it can sometimes take longer than you would anticipate to remove those people. I certainly remember your I'm sorry about your aunt and, the health issues that you were facing as well. So I am inclined to reduce the lien, particularly because it is in so much better condition than it was when we first met. You don't have anything else to add, or I'm just go ahead and make a ruling? All right. I reviewed the lien reduction application and the city code provision that is applicable and have considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and respondent. In making this ruling, the factors that I am considering are the actions taken by the applicant to correct and the time that it took to bring into compliance, especially given health issues and other challenges involved, taking into account the accrued amount of the enforcement lien compared to the market value of the property. I think it's almost about a little bit less than 10% of the value of the home. This would be the lien. Financial hardship, I think there's considerable financial hardship and other mitigating circumstances, including the health issues. And it's also your homestead property as well, correct? I will recommend that the city council reduce this lien. We'll reduce it by $9,000. I know you request for $9,400, but we'll reduce it by $9,000 based upon the factors considered above. In addition to the lien amount, the lien will also have to include the costs that were incurred by the city, which was, what was that amount? That was like 200 something.
With the lot cleaning, it was, I want to say 338.
Let's see.
The lot clean is a hard cost that would have to be paid.
The cost of recovery was $216.58, and then you have the lot cleaning, which was $116 as well, right?
Correct.
So we're not reducing those; those stay on, and then whatever the lien amount, I think was $9,900. Reduce that by $9,000 to make that $900 plus those hard costs. Are you okay with that? Does that work?
Yeah, how long do I have to get this paid?
What is that? 30 days from the entry of the order.
Well,
Actually, it's immediately.
If he
Sorry.
wants to pay it tomorrow, we can reduce and get the invoice down to legal for you to do that. Otherwise,
It has to be approved by the council, though,
it
right?
has to go back to council.
Yeah.
Which will be-
Right,
which will
right.
be in November. Okay, well, I need a little pump up time to get the money.
Yeah.
And then-
Because this is just a recommendation to the city.
Then it's
and-
90
yeah.
days from that date.
Okay.
90 days
Okay, 90 days
after the city
after
council.
council. Okay.
So again, just to reiterate, the lien amount will be $900 total for the fines, and then plus the hard cost of $216.58 plus the lot cleaning. Sorry, make sure my math is correct.
I was going to say, there is an, look at Exhibit 2 or 3.
Is it this guy?
Yes.
Sorry, so the lot cleaning fee, $119.50, administrative costs, $216.58, and then the total daily fines will be reduced to $900. So altogether, that'll be the balance that you'll have to pay after, or assuming that the city council accepts our recommendation. It is so ordered. You will receive a written order from today's hearing, which would, again, just be a recommendation to city council. You'll have notice and opportunity to attend the city council meeting where the recommendation will be considered. Thank you, Mr. Kirk, and best of luck to you. Okay, so we're going to move forward to the Massey hearings. We have 3 on the agenda. The first one is 25-59. This is for Michael Ray Stinson and Holly Stinson as trustee. The property is 2755 Tomoka Avenue.
Good day, sir. This case was heard last month. He did come into compliance, like you said, within a week. And like I recommended, no fines, no administrative costs, since he did comply within a week, like he said he would. That's all I got.
Okay. Do you guys want to add anything? Okay. All right, fine. Based on the evidence and testimony presented, the notice was properly provided to the respondent, and the respondent did appear. Evidence demonstrates that the property located at 2755 Tomoka Avenue in Titusville, Florida, is no longer in violation. No fines or costs will be assessed. Certified copy of this order will be recorded in the public records constituting, no, not constituting a lien, sorry. Respondent, no, that's it. That's it for the order. Thank you. The next one is 25-44. This is for the Manzos at 2655 Ollibird Drive. Are you guys sticking around for more entertainment, or? Oh, okay, gotcha.
So
Sorry.
I have two items to submit. The first is the affidavit and notice for the Massey hearing, and then the cost recovery statement. And again, that was 14614.
Thank you.
So once again, this is the Massey hearing for case number 25-44. The respondent, Richard Manzo, is here in attendance. The violation address and mailing address is the same at 2655 Alley-Bird Drive. And our violation sections are section 28-365, storing of shipping containers in residential districts, and section 28-373, temporary storage units. So the notice of Massey hearing was posted at City Hall and hand-delivered to the respondent on the property on September 26, 2025. The certified and first-class mail were sent on September 10th, 2025, and the certified letter, and that is wrong. That should be September 14th, 2025, not June. So this case was originally heard August 11, 2025. The respondent, Robert Manzo and Robert Manzo Jr. were present and provided testimony. The respondent was found to be in violation of section 28-365 and 28-
It's Richard Manzo, right?
Yes.
Okay, sorry. You said Robert, sorry.
Oh, I'm sorry.
All right, sorry.
I do apologize.
No, it's fine.
All right, so.
Sorry, I derailed you from your train of
It's
thought.
okay.
I'm sorry.
And I apologize for the mistake in my presentation. I apologize. Respondent was found to be in violation of 28-365 and 28-373 in order to correct the cited violation by removing the shipping container from the property or by obtaining a permit or variance to keep the container on the property by noon on October 10th, 2025. Compliance was not achieved, a fine in the amount of $50 per day per violation, commencing on October 11, 2025, and continuing daily until the violations are corrected. The administrative costs in the amount of $146.14 were imposed. So an application for a shed permit was submitted on August 18, 2025. Review comments were sent to the owner on August 18th and September 11th, 2025. It has also been brought to my attention last week. Additional comments were submitted on October 7th, and review comments were submitted back to the applicant on October 8th. At the time of the meeting, as of we're standing right now, the permit has not been issued, nor has it been approved. And I did find during my inspection this morning that the shipping container remains on the property. There's our definitions. And again, these are from the original hearing, showing the shipping container in the backyard. And from the September 26th, and again, there was photos taken by Code Officer Lewis on Friday, October 10th, and again, the container remains on the property. So again, conclusion of facts in this case, at this time, the shipping container remains on the residentially zoned property. No permits have been issued allowing the container to stay on the property.
All right, thank you. I do remember, obviously, the Mansos coming before. I'm sure you guys have a lot of information about your efforts, so if you want to come on up and let me know. Remember, very well articulated arguments in writing and in person by you last time, so I'm sure you have more details to provide me now. What's the process going, and where are we at on getting a permit or a variance?
So yeah, exactly. So basically what we're looking at today, we're asking for is if we could just have just more extended time just to be able to go through the application process more with them, because the city is asking for more, documents and more plans and stuff. That way we can send to them. That way we can at least get a decision on whether it gets approved or not. And at that point, if not, then we go to the variance, if, as an option. But yeah, basically, because we sent documentation and they asked for, they had comments and reviews and we sent it. And now after talking to May, we understand too now that we'll hire a engineer to construct more plans, more extensive plans that the city wants to see from as well with that. And so if we could just have, just more time basically just to put that together.
When was your last communication with the city?
It would have been last week.
What are they asking you to provide now?
More information on the foundational, like the anchoring systems and just renderings of the building. And that was a little bit of confusion on our end as well, because, because we're not obviously, builders or anything like that. We have a handyman who's been helping us through this process, a handyman contractor who was advising us. And what he gave us, apparently, the city wants more. So at this point now we know we'll seek out an actual, we'll seek out an engineer to, give all of the things that the city wants.
Was this with the city planner?
Sorry, excuse me?
Who have you been in communication with? Is it the city planner that you've been in communication with?
Building department is who I was communicating with, yes.
Okay. Officer May, do you know what the status is on the various efforts that they're making? And
So in those initial review comments that came out in August, they were requesting building drawings and plans in compliance with the Florida Building Code, and then additional information on the setbacks, because there are easements in the backyard of the Alley-Bird property, and they needed to demonstrate that the container can be placed outside those easements. So there has been written responses and updated drawings submitted. But again, right now, the planning department is saying that the size of the shipping container will not fall outside those easements. And they're still waiting on a set of engineered building plans or a set of drawings to confirm that the container itself meets the Florida Building Code.
but are you asking for a variance now on that, or is
No,
that? Sorry, I'm just confused.
Yeah, they're still waiting on all of the review comments to be responded to at this point. So from the original comments that came out in August, there's still a couple of items that they have not responded to. And that's why in the September and as well in the October review comments, they were given more details about what they were needing.
But you just got, Richard, you're Richard Jr., right, or Robert? You just got the email in October from the city for more information? Is that?
That's correct, sir. October the 8th. And actually at that one, it's still being denied by both planning.
By both what?
But by the planning department, as it will not be approved, as it's not allowed. So they asked, the third of that was they want to see engineering, which may or may not be valid. because it's still has been denied by the building, or by the Community Development Department. And this has been ongoing since April, so.
Right, Richard, I don't want to wouldn't want to indefinitely extend it, but what type of more information? You say you need to get an engineer and everything involved. I mean, what are we talking about? What would that entail? Oh,
Can I
yes.
submit, this is a copy of the review comments from the October 7th, the last.
October 7th? Okay, wow, that's just, okay, all right, let me take a look. Thank you.
Emailed on the 8th.
Bear with me a second, let me take a look at this.
Yeah, no, of course, yeah.
All right, so this was just last weekend of last week. What would that require for you to get together to submit to them? Because, I mean, all it says is engineering plan has not been submitted. What would that entail for you guys? How long would that take?
Well, you know, we were hoping possibly till January, just because we know we are coming up on like holiday seasons and, you know, extended, you know, maybe weeks out of office. And so maybe if we could have until then, we're sure that we can get everything that the city wants now, because like I said, there was a little bit of confusion back and forth too, just from what we thought the city wanted to, because in a couple of the emails too, I said, you know, if you could specify, you know, exactly what was needed, because a lot of the responses were kind of short and a little vague. And again, you know, I'm not a builder like this necessarily, and we were using, you know, recommendations from our contractor, handyman. So now that we have a much better idea of what they want, engineered plans and all of this stuff, you know, if we have until January, like I said, with the holidays coming up, we're sure that we can definitely meet that.
My initial thought when I saw this come across the agenda again, and you know, no offense to you or your father or anything like that, I'm like, well, it's a violation. It's still there. It's still in violation. But we have something from the city asking them for documents last week, so I hate to.
And I agree with that, but I also agree with, it was put there early on, they were told early on, it's not allowed, and we're leaving it there asking for forgiveness to go forward.
Yeah.
So if you are going to continue it, I would like it to be shorter than January.
Yeah, I don't think I would grant something to January.
Because the fact is, it's not going to be approved.
Yeah, but, right. But they have to have the opportunity to go through the process, and to the extent the city of Titusville, the building department is asking for more information, I think it'd be hard for me to find them in continuing violation while that's still pending. But I do think to January is a little bit much. I'm inclined to just punt this 30 days to next month's Massey hearing agenda, to give you some time to, you know, submit the documentation. And then, you know, if Officer Glennon is correct, it sounds like maybe a decision is already made, but at least that wouldn't be pending anymore.
Yeah,
Yeah.
Can I ask just one question?
Of course.
Because again, this is an area I'm not super knowledgeable about how long it takes, like for engineering plans. So do you think it's a realistic time frame in 30 days to find an engineer to?
I'm not an engineer.
Okay.
I can't
Okay.
answer that question.
Are you still having issues? Is the HOA still involved?
No, yeah.
Yes.
Oh.
They are continuing to call about
Okay, well, I
the
didn't know.
status of the container.
Yeah, well, they don't want to expend their own legal fees. They want code enforcement to take care of it for them, probably. So, but that makes sense. So, all right.
And then if I may say, sorry, one more thing too, I was gonna say, because originally too, back in August, you were saying too, because, you know, we were seeking a variance at that point, and now we're going through the approval process. You were saying we had to have the permit, or at least submit for the
Well,
permit
that's because
application.
you already had it on site. The actual process would have been put in all the plans prior to, and then when it was approved, have it delivered.
But the point is that even if you're saying, you know, which we're not sure of, but even if they reject it, we would still be entitled to a variance at that point, correct?
Well, you'd be entitled to an appeal to that, yes.
But for a variance as well, right? Is that how
Well,
you
you
said
can
the
always
process
apply for
works in
that, yes.
August?
Yes, you could
Okay.
still apply for that.
Thank you.
Do we enter an actual order pursuant to the Massey hearing, or am I at liberty to just table this for 30 days to next, or-
You can do that if you want to go for those 30 days and allow them to get the engineering in.
Yeah, I would like there to be something from the city with some sort of finality rather than asking for more information. And so, but, you know, now that you have that, let's say 30 days, you haven't submitted something, then, you know, we're going to obviously move forward with imposing the fine and everything at that point. But, yeah, I don't think a formal order is needed right now. Let's just table this for 30 days so he can have the time to submit it, and then we'll be back here in a month to see what the status is. All right?
Awesome. Well, thank you so much.
All right.
Thank you.
I will get you another copy. So they should have been emailed to you.
Okay.
But give me 1 minute and we'll get you a
Okay,
copy.
no problem. All
All
right,
right.
thank you.
Give me 1 second. Okay, we'll move to 25-71, which is the George Raymond Donald Senior Trust at 8251 Wendover Way. Sorry, I thought you guys were the other one. I just remembered your faces. Sorry about that. All right.
So, two exhibits here. We've got the affidavit for the notice of Massey hearing and then the cost recovery statement in the amount of $128.53.
Thank you. Go ahead.
So, all right, Massey hearing, case number 2571. Again, this is George Raymond Donald Senior Trust. Our violation address is 8251 Wendover Way. We had 4 violations. 302.7 for accessory structures, 304.1 for general exterior maintenance, 301.3 for vacant structure and land, and 305.1 for general interior maintenance. So we had proper notice on the Massey hearing. So on July 14th, 2025, Julie and George Donald Jr. were here and provided testimony. They were given honor before September 5th, 2025 to secure all the existing structures against entry and submit for a permit for the demolition of the structures. And then they were further ordered to complete the application process and obtain the permit for demolition of the structure by October 10th, 2025. So on September 5th, 2025, the reinspection of the property was completed. I did confirm that all the front and back buildings had been boarded and that the fuel pumps had been removed from underneath the canopies and secured. There was not a building department or a demolition permit application on file as of September 5th, but as of October 10th, 2025, we did have a demolition permit issued. So as of right now, and an inspection today found all the structures remained secure, and confirmed the building, or the demolition permit was issued Friday, October 10th.
Great.
So,
All right, now do you guys want to add anything? We're good, or?
We got the permit. It was to text 1 million people every 3 days to keep on top of it and a lot of hoops, but we finally got this. We want this building gone more than you do.
Well, I don't really care. It looks crunk to me. And dope. I think we'll spray paint it on there, right? Yeah.
Oh, yeah.
But you got it October 10th, right? I mean, perfect.
I have some papers if you want to handle it. I'm sure you probably have them all in your computer, but I
Yeah.
did them for you anyway.
Are the costs technically still due on these? Yes, that's so. Okay. Wonderful. You guys haven't paid the reimbursed the city of the cost for the code enforcement yet, right? The 100, so, okay, all right. All right. I find based on the evidence and testimony presented that notice was properly provided to respondent, and respondent did appear. Evidence demonstrates that the property located at, let me get that again, sorry, 8251 Windover Way, Titusville, Florida, is no longer in violation. Therefore, there's no continuing violation of the prior provisions. The cost of, what is that amount? $128.53 have not been paid. So that'll be the only amount that's left due and owing on this to close this out. A certified copy of this order will be, well, it doesn't need to be recorded, will be entered and provided to you all. So the respondent should be sure to coordinate and talk to the city to make sure that the final cost invoice is paid. Okay?
The sheriff's cop gets it taken care of as soon as we get the bill.
All right. Awesome.
we will
Did,
get that.
did they need to get a bill, or do you guys just
Not received anything with any amounts like that, so no.
The invoice would now be produced after this.
Oh, I see. Okay, that makes sense. All right. Perfect. All right.
We will get it to you.
Reduced always sounds good.
Yeah. All right. Thank you, guys. I appreciate your diligence in getting that done.
Thank you.
All right.
Thank you so much, Meg.
All right.
You'll have a great day.
All right.
Thank you, sir. See you soon. Will do.
Take it easy. All right, we'll move to our initial hearings. The first one is 25-60. This is Uwe Shorensky, 1635 Bahama Street, Titusville, Florida.
All right, I got 3 items to submit. The first one is the notice of violation and affidavit. Where's the affidavit? There it is. The second is the notice of hearing and affidavit, and the third is the cost recovery statement in the amount of $312.38.
Thank you.
Okay. All right, this is the initial hearing for case number 25-60. The respondent, U. Shorensky Trust. The violation address and mailing address is 1635 Bahama Street. Our violations are of section 102.2 for maintenance and section 505.1 for running water. So my initial inspection was completed on August 21st, 2024. They were given until August 30th, 2024 to come into compliance. Certified and first-class mail was sent to the listed owner on August 21st, 2024, and the certified mail was signed for on August 26th, 2024. Today's hearing was posted at City Hall and on the property where the violation existed on September 26, 2025. Certified and first-class mail was sent on September 10, 2025, and the certified mail was signed for on September 13, 2025. So we received a complaint from the Water Department in reference to an outstanding bill and disconnection of service. The inspection of the property found evidence that the house was occupied, and as a car was observed parked in the driveway, we had personal items and trash on the property. Photos were taken and a notice of violation was posted. So during follow-up visits on October 20th, I did speak with one of the occupants who explained that Lenani, who is the daughter, had received paperwork from the probate attorney and would be stopping by the water department to see additional items were needed to get the account back reconnected. I did confirm with the water department that the daughter came in to provide the death certificate, paid a past due amount, and she received additional information about lien payments and additional documents they were needing from the attorney. So as of the reinspection, the house remains occupied without any water service to the property. So 102.2 talks about the maintenance and that utilities must be provided if the property is occupied. And again, 505.1, that water is required for sinks, bathing, cleaning, etc. So these are photos from the posting of the hearing notice on September 26, 2025. The property has been continuously occupied since the beginning of this case. And the conclusion of facts are that the house is occupied and we do not have water service for the property. We are requesting that the respondent correct the violation on or before noon of November 7th, 2025 by reestablishing water service with the City of Titusville Water Department. The respondent does not comply by November 7th. It's requested that a fine of $50 per day per violation commence on November 8th and continue until the violations are corrected. And we are requesting administrative costs in the amount of $312.38 be assessed, and that they need to contact me to schedule a reinspection.
I see that on the contact with the owner, it says that you had a follow-up visit on December 20th. Is that correct? Or
Yes, sir.
so last year? We haven't heard anything from this Leilani since then?
Not since then. Not with her, though I have met other individuals entering and exiting the house.
Okay.
That said they are staying there and
With no running water?
No running water.
Okay. All right. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Uwe R. Shorozensky Trust is the owner of the property with the address 1635 Bahamas Street, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for the hearing. Based on the evidence presented, I find that violations of subsection 102.2 regarding maintenance and subsection 505.1 regarding running water exist upon the property, and respondents were given a reasonable notice of time to correct the violations, but have either failed or refused to do so. The corrective actions will be to remove all the debris and personal items from the, right, from the, what was the maintenance?
We're just requesting that water
water?
service be
Okay,
reestablished.
the water service be, move back to the recommendation right there. Okay, I'm sorry. Sorry, so water service be reestablished. Additionally, I find that the city has incurred costs in the amount of $312.38. Such amount shall be included with this order. Respondent shall be given until November 7th, 2025 to correct the violations. Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by November 7th, 2025, a fine will be entered in the amount of $50 per day per violation, of which there are two, commencing on November 8th, 2025, until the violation comes into compliance. Further, and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right. Moving on to the next one, which is 25-64, Brian Kenneth Davis at 302 Willow Street.
All right, again, I've got 3 exhibits to submit. The first is the affidavit and the notice of violation. The second is the affidavit and notice of today's hearing. And the third is a cost recovery statement in the amount of $241.94.
Thanks.
Once again, this is the initial hearing for case number 2564. Our respondent is Brian Kenneth Davis. Our violation and mailing address are the same, 302 Willow Street in Titusville, Florida. And our violation is of section 308.2.2 for refrigerators. So the initial inspection was completed March 7th of 2025. They were given until March 21st, 2025 to comply. Notice to the respondent was mailed on March 10th, 2025, and the certified mail was returned unclaimed, returned to sender on March 29th of 2025. The notice of today's hearing was posted at City Hall and on the front door of the property on September 26, 2025. Certified mail was sent on September 10, 2025, and the certified letter has yet to be claimed or returned. So we received a complaint concerning trash, junk, and debris accumulating in the yard. A review of the past cases found daily fines running for section 12-23 for trash, junk, and debris. And this is referencing Magistrate hearing case 23-10. An inspection of the property found the violation ongoing for the trash, junk, and debris. But in addition, there was refrigerators with its doors still on in the driveway just off the sidewalk. No answer to knocks at door, and the notice was posted. There has been no callbacks or communication received back from the owner. Since the initial inspection, additional appliances have been brought onto the property, and the refrigerator still remains in the driveway. So again, refrigerators or similar equipment shall not be abandoned or stored on the premise without removing the doors first. So this is our photo from posting of the property. And again, we've got the refrigerator outside the fence. The gate into the pool area still is open, and we've got multiple appliances in the backyard. This is on the north side of the pool enclosure. This is our posted notice of hearing. So again, our conclusion of facts, we do have multiple appliances being stored on the property. without their doors being removed. We're requesting that on or before noon of November 7th, that the respondent remove all the discarded appliances from the yard. Request that administrative costs in the amount of $241.94 be assessed, and a fine of $250 per day commencing April 8th if the violation is not corrected, and to continue daily until the violation is corrected, and to contact the code officer once completed.
Can I ask a stupid question?
Yeah.
If they left the fridge there but removed the doors, would that put them in compliance?
Yes, if they remove the doors on all of the appliances in the yard. Yes, sir.
But then they'd have other violations, right?
They're
for-
still running fines on the 12-23.
Okay,
It's just, at this point, they've got multiple refrigerators.
but that's okay, we just remove the doors,
We
right?
can remove the doors. That would be an option.
That
Would be absolutely an option
Correct, that would only correct that violation.
Right,
to stop.
And still inclusive of junk and debris.
right,
The
right.
junk and debris remains in violation. It's running daily fines at this, based on case 23-10.
But in
I'm
entering.
trying to get
yeah.
a response back from the respondent because of just the additional junk and everything that's being brought to the property.
And it's not just a refrigerator at this point, it's all the appliances, right?
Yes, sir.
But the corrective action we should issue in order is to remove all of it, not just to simply remove the doors, right?
Removing the doors on all of the appliances would satisfy 505.1, but we are requesting that all the
Yeah,
appliances be
I
removed.
I agree. I feel like that's just kind of silly. I just wanted to make sure I understood the code correctly. All right. Okay. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. Get that name again, everything. I find that respondent Brian Kenneth Davis is the owner of property with the address of 302 Willow Street, Titusville, Florida, 32780. Find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections 308.2.2 regarding disposal of refrigerators exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for this violation is to remove the refrigerators and other appliances from the driveway and the rest of the property. Additionally, I find that the city has incurred costs in the amount of $241.94. Such amounts shall be included with the order. Respondents shall be given until November 7th, 2025 to correct the violations. Respondents shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by November 7th, a fine will be entered in the amount of $250 per day until the violation comes into compliance, which would start on November 8th, 2025. Further and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right. Moving to the last one, 25-69, Natividad Gonzalez at 412 Mendel Lane.
Good afternoon, sir.
Hello, officer. How are
I'd
you?
like to enter into evidence first exhibits, the affidavit, notice of hearing, notice of violation, cost recovery statement.
Thank you, sir.
Okay, this is case 25-69, initial hearing. Property located at 412 Mendel Lane in Titusville. Respondents are Natividad Gonzalez and Arusin Santiago. We mailed all notices to 412 Mendel Lane. Violations were 1223 junk and debris and 13-73 inoperative vehicles. The initial inspection date was July the 24th, 25, and the compliance date was 8/11/2025. It was certified and first-class mail were sent 7/24/25, notice of violation was given to the owner's son at the time of inspection. Certified mail was returned unclaimed on 8/21/2025. Notice of hearing was posted at City Hall and on the property where a violation exists on 9/16/25. Certified mail and first-class mail were mailed on 9/10/25. Certified mail sent to the listed owners was returned unclaimed, unable to forward 6/4/24. 6/4/24. Been 10/4/24. I don't know where that come in there at. I've been 25.
25.
But
That day couldn't be more
the
wrong.
mail came back as unclaimed. I know what that is, but I won't admit it. Okay. An inspection was completed on the property. We received a complaint about overgrowth, junk, and debris. The overgrowth was taken care of right away, so it didn't even get put on the docket. Junk and debris and inoperable vehicles. A small trailer with junk and debris was out in the front yard on the right side of the driveway, and lots of debris under the carport area. Silver gray Dodge pickup parked partially on the property and in the street and with an expired tag, and a white Mazda with no tag in the front yard. I spoke with the owner's son the day of the inspection and again on 9/19/25. On the 19th, I showed him exactly what needed to be done to bring the property in compliance. The truck was moved out of the street and into the driveway, and the Mazda was moved to the side of the driveway. Neither still has a current tag. But on 10/7, the Mazda was gone from the property. And that's your definitions, the junk and debris and inoperative vehicles. You see the truck there with no tag in the Mazda. Like I said, the Mazda's now gone. You see all the items to the right side there, that little small trailer has a lot of debris on it. There's a lot of loose items and junk and debris under the carport area there. And junk and debris still remains on the property as of this morning, and one inoperable vehicle remains on the property. City recommends we order a respondent to correct the violation on and before November 7th, 2025, by removing all the junk and debris on the property and any inoperative vehicles, or obtain proper registration for such vehicles. Order respondents be addressed administrative cost in the amount of $135.18. And if they do not comply by November 7th, 25, it's requested at a fine of $100 per day per violations be imposed for each day the violation continues, and they must contact me for such. That being said, the son that I met on the property the day of the initial inspection, he called me this afternoon. He is actually doing cleaning the property for his mother. He called me. One vehicle's gone. He said one vehicle will be gone today, and the rest of the property will be in compliance by tomorrow afternoon.
So he'll be well within the time frame to comply then.
According to him, he apologized. He's had a medical situation.
All right. Thank you, Officer Frank. I've accepted and considered documentary evidence, including photos and sworn testimony related to this matter from city staff. I find the respondent, let me get the name again. I keep forgetting the names. Natividad Gonzalez and Rusin Santiago is the owner of the property of the address 412 Mendel Lane in Titusville, Florida 32796. Find that all required notices were provided in accordance with Chapter 163 Florida Statute and the City Code, and notice was met for this hearing. Based on the evidence presented, I find the violations of sections 302.4 and 12 what? That's the wrong one. No, that's right. Sorry.
23 and 13.
And 13-73. Which is regarding property maintenance, and then inoperative vehicles exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective action for these violations would be to clean the debris and personal property from the property in the shed, and then to remove or obtain the registration for the inoperable vehicle. Additionally, I find that the city has incurred costs in the amount of $136.28. Such amounts shall be included with this order. Respondents shall be given until November 7, 2025 to correct the violations. Respondents shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violations by November 7th, a fine will be entered in the amount of $100 per day per violation, of which there are two, per day until the violation comes into compliance, starting on November 8th, 2025. Further and future violations of the same section shall be classified as repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you. All right, that was simple for the initial hearings. Do we have a report from the code enforcement manager?
Yes, sir. Starting in next month, November's meeting will now be at 1 p.m. in the afternoon.
Perfect. Do we have the date on that again? I know it's the, I just need to make sure I put it on because I screwed up the dates this month for some reason.
November 10th.
All right. Starting at 1. Perfect. Thank you so much for making that accommodation. All right. All right, that's it. All right. Thank you all. We're adjourned.